Welcome back to Understanding the BC Parenting Coordinator Participation Agreement. Over the last episodes, we've discussed authority, confidentiality, dispute resolution, court involvement, fees, complaints, and many other parts of the agreement. We're going to finish the series a little differently. After nearly 2 decades as a parenting coordinator, I've noticed that many disputes aren't caused by the parenting issue itself. They're caused by misunderstandings about the process. Parents often arrive with assumptions about how parenting coordination works, and those assumptions sometimes create more conflict than the original disagreement. So today we're going to talk about the 10 biggest myths and misunderstandings I see in practice. Myth number 1 is the parenting coordinator works for me.
I don't understand. How is it a myth for a parent to think the parenting coordinator works for them? Many parents probably think, I hired the parenting coordinator, so of course they work for me. What's wrong with that?
The parenting coordinator doesn't work for one parent. The parenting coordinator doesn't represent either parent. The parenting coordinator is a neutral professional working within a process designed to assist both parents. One of the most difficult moments in many files occurs when a parent realizes that neutrality is not the same thing as agreement. Just because the parenting coordinator doesn't agree with you doesn't mean the parenting coordinator has stopped being neutral. Myth number 2 is everything I tell the parenting coordinator is confidential.
We spent an entire episode on confidentiality. But this must be a common misunderstanding.
It probably creates more confusion than any other topic. Parents often assume parenting coordination works exactly like counseling or exactly like speaking to a lawyer. It doesn't. The agreement creates different categories of information. Some information receives stronger protection than others. Understanding those distinctions helps avoid a lot of disappointment later. Myth number 3, the parenting coordinator can do whatever they think is best.
Yes, we already discussed that parenting coordinators only have jurisdiction to implement the pre-existing parenting plan.
Correct. Many parents assume parenting coordinators can make whatever decision they believe is best for the child. In reality, parenting coordinators operate within delegated authority and defined limits. Authority matters. Jurisdiction matters. The first question is never, what would be the ideal solution? The first question is, do I actually have authority to address this issue? Myth number 4, the parenting coordinator is basically a judge.
A lot of people think that a parenting coordinator is a mini judge or a pocket judge.
And it's understandable. Parenting coordinators sometimes make determinations, but that doesn't make them judges. Most parenting coordination work involves implementation, communication, problem solving, information gathering, and helping parents reach agreement. Determinations are only one part of the role. Many successful files involve remarkably few determinations. Parenting coordination exists within the broader family justice system. The parenting coordinator may assist with implementation issues and make determinations within delegated authority. The court remains the ultimate authority. Parents sometimes think they must choose between parenting coordination and court. The reality is that both exist within the same overall system. Myth number 5, the parenting coordinator is a witness or expert witness.
The reality is that a parenting coordinator is neither a witness nor an expert witness.
Correct. The parenting coordinator's role is to help parents resolve disputes outside of court, not to provide evidence in court. Parenting coordinators are expected to remain neutral and independent. Their determinations, recommendations, and reports must stand on their own without the parenting coordinator being called to explain or defend them. If a parent disagrees with a determination, the proper remedy is usually to seek review through the court process, not to require the parenting coordinator to testify. In some cases, a court may suspend the appointment if it has concerns about the process. The agreement also recognizes that compelling a parenting coordinator to participate in litigation can be costly. If a party requires the parenting coordinator to attend court or provide evidence, the agreement generally requires that all related fees, legal costs, disbursements, travel, waiting time, and preparation time be paid in advance. Parenting coordinators are appointed to keep families out of court, not to become witnesses in court. Myth number 6, if I don't participate, nothing can happen.
This one surprised me when we discussed it.
It surprises many parents. Some people assume participation gives them complete control over whether issues move forward. The agreement specifically contemplates situations where participation is incomplete. Children's lives continue, schedules continue, schools continue. The process is designed to function even when participation isn't perfect. Myth number 7, if I refuse to pay, the process stops.
Another surprise from the fee episode.
Exactly. Many parents assume non-payment automatically brings parenting coordination to an end. The agreement contains provisions intended to reduce the ability of one parent to frustrate the process simply by refusing to contribute financially. Otherwise, one parent could potentially disable the entire process whenever a difficult issue arose. Myth number 8, recommendations and determinations are the same thing.
We've touched on this before, but I think many people still confuse them.
They do. A recommendation is generally guidance intended to help move a matter toward resolution. A determination is a formal exercise of delegated authority. The difference is important. Many parents treat recommendations as though they are determinations. Others ignore recommendations entirely. Neither reaction is particularly helpful. Myth number 9, I can fire the parenting coordinator whenever I want.
We've definitely talked about that one.
Yes. One parent generally cannot simply terminate the parenting coordinator because they're unhappy with a recommendation or determination. The agreement is structured that way because parenting coordination would become difficult to operate if either parent could end the process whenever disagreement arose. Myth number 10, if the parenting coordinator disagrees with me, they're biased.
This one probably comes up a lot.
Very often. And it's understandable. Parenting disputes are emotional. People care deeply about their children. But disagreement and bias are not the same thing. Sometimes the parenting coordinator disagrees because the information points in a different direction than the parent expected. Sometimes the parenting coordinator lacks authority to do what a parent is requesting. Sometimes an implementation issue has a practical answer that neither parent particularly likes. Those situations don't automatically indicate bias.
After all these years, if you could identify one mistake that creates more problems than anything else, what would it be?
Treating parenting coordination as another opportunity to prove who was right in the past. Most parenting coordination issues become easier once parents shift their focus from who was wrong to what needs to happen next. Implementation is fundamentally forward-looking. When parents make that shift, the process often becomes much more productive.
Let's end with this. What's the one thing you wish every parent understood before signing the agreement?
That parenting coordination is really a structure. It's a process. It's not designed to make people friends. It's not designed to erase conflict. It's designed to help parents continue parenting despite conflict. Once parents understand that, many parts of the agreement suddenly make much more sense.
So after all these episodes, what's the overall message?
The Roster's Parenting Coordination Agreement isn't just a contract. It's a framework for implementation, a framework for communication, a framework for decision-making, a framework for managing parenting disputes without repeatedly returning to court. Parents don't need to memorize every clause, but they do need to understand how the system works. That's the purpose of this series.
Thank you for joining us for Understanding the BC Parenting Coordinator Participation Agreement. If you've listened to the entire series, you now know more about parenting coordination than most parents do when they sign the agreement.
And hopefully you'll feel more comfortable participating in the process if parenting coordination becomes part of your family's journey. Thank you for listening.